A group of abortion care providers is suing the state in a challenge against Indiana's near-total abortion ban. The three-day bench trial began Wednesday at the Monroe County Justice Center. Planned Parenthood Great Northwest, All Options, and an Indianapolis-based OBGYN filed the lawsuit seeking to, quote, broaden and clarify legal abortions in the state. The ban only allows an abortion if the pregnant person's serious health or life is at risk. If there's a lethal fetal anomaly up to 20 weeks, and in cases of rape or incest, but only up to 10 weeks. For more on the case, we're joined by IU Professor of Law, Jody Madeira. Professor, last year, the Indiana Supreme Court ruled the abortion ban did not violate the state constitution. So what exactly are the providers arguing for?
Well, I think that's an excellent question. And what the providers are really hoping for is to qualify those terms, serious risk to life or health. And so basically those aren't medical terms. And what they're hoping is that there can be some translation to provide more guidance to doctors to help save women's lives when, in fact, those kinds of complications arise.
How is the state then responding to the lawsuit?
The state is responding in a number of ways. First of all, they're saying, why all these hypotheticals? Why haven't you put forth a real person? And of course, that could expose a woman to negative ramifications in career, in social life, etc. From others. For example, if she comes out and says, I had an abortion, even for this serious health risk. And so hypotheticals are also what allow us to get the broadest range of expertise, perhaps, or exposure to what kinds of risks could merit a constitutional abortion. And they're also basically arguing that this is very unusual, and perhaps doctors already know what to do in these situations, and that the remedies at hand are already adequate.
How likely do you think it is that this case will have national ramifications?
I think it is very, very likely. So Indiana was one of the first, I think the first, to pass an abortion ban when they passed SB 1. And really, it's one of the first states to look at whether a constitutional challenge as applied, in other words, the law as applied to particular situations that arise, needs to be more defined than just terms like serious risk to life or health.
When do you think we'll hear the judge's decision, and do you expect either side to appeal?
Great question. So I think Judge Hanlon said that she would render a decision in about 60 days. She was very, very prompt the first time she reviewed the constitutionality of SB 1 as a whole. And then I believe it's very, very likely that either party will appeal. Neither party wants to see their answer be no. And of course, so I anticipate an appeal to the Indiana Court of Appeals. And from there, it's a question of whether the Indiana Supreme Court will hear it if a party decides to appeal there as well.
Thank you. That was Jody Madeira, Professor of Law at the IU Maurer School of Law.